Mr. Baloo, I need you to unmute that microphone again.
Hello?
Good morning. Thank you. Can you hear the court?
Yeah.
Okay.
Calling the case of the People versus Dean Eldon Baloo. Counsel identify for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Baloo.
You are Dean Eldon Baloo?
Yes, sir.
All right. And previously, you pled to the charge of assaulting, resisting, or obstructing, plus a habitual criminal offender. Second, that makes that a felony with a maximum penalty of 3 years in prison. The minimum is discretionary with the court. The pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 0 to 21 months. Mr. Rowe, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Is there anything of a factual nature that you wish to add to, explain, or controvert?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Webb, on behalf of the people?
Thank you, Your Honor. I've reviewed the reports. I have no additions or corrections to make to them, and I believe the guidelines are correctly scored.
Mr. Baloo, is there anything you wish to say to the court before the court passes sentence?
No, sir.
And Mr. Baloo, you have no objection to be sentenced via Zoom, is that correct?
No, sir.
That's correct that you have no objections. That would be a yes. Or are you
Yes, yes.
objecting? Okay,
That's correct.
all right. Mr. Rowe? Anything you need to say on behalf of Mr. Baloo?
Your Honor, on behalf of Mr. Baloo, asked the court to honor the plea bargain in this agreement and follow the recommendations of the that are in this pre-sentencing report, Your Honor. Mr. Baloo, it should be noted that originally when he entered the agreement, it was an agreement to a 6-month cap. Because of various things that happened within the case, now it is now he has 248 days credit, Your Honor. So I think it should be noted that he has served his 6 months and then some.
Mr. Webb, on behalf of the people.
I just ask you to follow the plea agreement and the recommendation from the probation department.
Are there any victims present that wish to speak to the issue of sentencing? Let the record reflect there are no victims present either via Zoom or in person. Court has reviewed through the pre-sentence investigation report, does provide for sentencing guidelines of 0 to 21 months. The plea agreement is within the sentencing guidelines. In order to punish you for what you have done, to attempt to rehabilitate you, deter others from committing similar acts in protection of the community, there'll be a sentence of this court that you be placed on probation for a period of 2 years. Along with the statutory terms of probation, you're gonna have the following special conditions. You must not use or possess alcoholic beverages or other intoxicants. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must use prescription drugs only as prescribed for you by your licensed physician. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must take any medication prescribed for you by a licensed physician only as prescribed for you. You may perform 100 hours of community service as directed by the field agent. If you do so, the court will reduce your fines and costs by $700. You must complete mental health or domestic violence or other recommended treatment following assessment by a qualified community-based service provider. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtain written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation or release from jail. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate the conditions of your probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends, and holidays accepted. You must notify the field agent of service of any personal protection order upon you within 24 hours of that service, weekends, and holidays accepted. You must be in your approved residence between the hours of 11 p.m. and 6 a.m. unless excused by first obtaining written permission from the field agent. You will serve 6 months in the county jail with credit for 248 days served. You must pay a $68 state cost, a $130 crime victims fee, a $30 supervision fee that could go to $60 if the department decides to put you on electronic monitoring. Court costs of $500, a fine of $500. And how much are you charging for attorney fees?
Your Honor, estimate of $500.
And $500 in attorney fees. Probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, confine a probationer who is in violation of probation condition or who is conducting himself inconsistent with the public good. You must not use or purchase or otherwise possess recreational marijuana or be in the home or company of anyone who uses or possesses recreational marijuana. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from the field agent. And you must set up an installment payment agreement within 30 days of your release from jail with the Clare County Clerk's Office. You are entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate's rights form when it's presented to you, Mr. Ballou. Bond is canceled. Good luck to you, Mr. Ballou.
Thank you very much.
You're all set, sir.
Wilson, you and Mr. Moore need a few more minutes?
I do, actually, Judge, his client's gonna be here. We're wondering if we could take some time to work on maybe settlement before we heard the motion. I don't know what you had else this morning. You can just pass us to the end.
Sure.
Okay,
No
thanks,
problem.
Judge.
Sir, your client is in the waiting room. Did you
Yeah, I know.
say that?
He's only gonna be able to be by Zoom, so, can we just pull him up and I can just tell him?
Absolutely.
We're in recess.
Thank you,
All right.
Judge. Can I call him?
Yes,
I'll wait for you.
by all means.
I'll wait for you.
Thank you.
Oh, call it, go ahead.
All 55th Circuit Court is now in session. The Honorable Roy G. Mink presiding.
You may be seated. Calling the cases of People versus Christopher Carl Dietrich. Counsel identify for the record, please.
Sharon Besides, speaking on behalf of people.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Dietrich.
You are Christopher Carl Dietrich.
Yes, sir.
And how old are you?
30, sir.
Raise your right hand and be sworn.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Judge, the amended information was printed to the law library. Did you receive that?
I do have it. I have it in front of me.
Thank you.
Mr. Rowe, have you gone over the information with your client?
I've discussed it, Your Honor, yes.
All right. Does he waive reading of the information for today's purposes?
Yes, he does, Your Honor.
All right. And previously, he waived preliminary examination, is that correct?
Yes, Your Honor.
All right. And Mr. Dietrich, you're being charged with count 1, operating while intoxicated, third offense notice. That makes that a felony with a fine of $500 to $5,000, either 1 to 5 years in prison or probation with 30 days to 1 year in jail. You will be ordered to do at least 60 days of community service, could be up to 180 days. You'll be ordered into rehabilitative programs, pay costs of prosecution, or reimburse the government for any emergency response. And there's mandatory vehicle immobilization of not less than 1 year or more than 3 years. You're also being charged with count 3, operating while license suspended, revoked, or denied, second or subsequent offense. That's a misdemeanor, carries a maximum penalty of 1 year in the county jail and or $1,000 fine. Otherwise, the minimums are somewhat discretionary with the court. You understand the charges and the possible penalties.
Yes, sir.
There's one of 3 possible pleas that you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. Also, you're being charged as a habitual offender, third offense, which makes count 1 maximum 10 years instead of 5 years. You understand that?
Yes, sir.
The minimums are still some discretionary with the court. You understand that?
Yes, sir.
And you understand the 3 possible pleas, is that correct?
Yes, sir.
All right, answering to count 1, operating while intoxicated, third offense notice, how do you plead?
Guilty.
Answering to count 3, operating while license suspended, revoked, or denied, second or subsequent offense, how do you plead?
Guilty.
And answering to habitual offender, third offense notice, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be.
Yes, sir.
Court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to
Yes,
question
sir.
all the witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, sir.
You understand by pleading guilty, you give up each and every one of those rights.
Yes, sir.
Ms. Ambrositis, what is the plea agreement?
Your Honor, return for the defendant's guilty plea to count 1 and 3 as a habitual third, and the amended information will move to dismiss the remainder upon sentencing and running the appropriate appeals period. There is an agreement pursuant to Briggs and Killebrew that this would be a stipulated 14-month sentence, concurrent with his PV sentence. Restitution is to be determined to the victim of count 2, which is dismissed but is made part of this plea agreement. There is $100 for the Clare County Prosecutor's Office pursuant to statute, $50 for the blood draw reimbursement to MSP. And there is an agreement that the defendant is to plead in his 2 PV files. And the 186015 FH file needs to receive credit for time served, unsuccessful discharge from probation. And in the 19619 FH file, he is to receive credit for time served, remainder to be served concurrently with this sentence.
Mr. Rowe, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Diedrich, did you hear what was put on the record as the plea agreement?
Yes, sir.
Did you understand it?
Yes, sir.
And are you in agreement with it?
Yes, sir.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No, sir.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, sir.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, sir.
Is it your own personal choice to plead guilty?
Yes, sir.
And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything the court has told you, do you still wish to plead guilty?
Yes, sir.
Drawing your attention to on or about November 23rd of 2020, were you driving a motor vehicle on Lake Station Avenue in Garfield Township, Clare County, Michigan?
Yes, sir.
And prior to driving that motor vehicle, had you been drinking some alcohol?
Yes, sir.
You remember what kind of alcohol and how much it was?
Yes, sir. The 5th of Jack Daniels.
Okay. And that made you intoxicated, is that correct?
Yes, sir.
Did you end up taking a breathalyzer or blood test?
Blood test, sir.
All right. Do you know the results of that test?
No, sir.
Mr. Rowe, do you know the results of that test?
Your Honor, I'm afraid I don't at the moment. I'd ask the prosecutor.
Okay. Well, it doesn't matter. He said he was intoxicated and if he drank a fifth, that he definitely would have been well over the legal limit. And at the time that you were operating that motor vehicle, did you have a license to operate a motor vehicle?
No, sir. I was on suspension.
Okay. All right. And you were previously convicted of operating while intoxicated on or about February 10th of 2014 in the 80th District Court for Clare County or state of Michigan, is that correct?
Yes, sir.
And you're also previously convicted of operating while impaired on or about November 30th of 2016 in the 80th District Court, Clare County, state of Michigan.
Yes, sir.
And you were previously convicted on or about February 14th of 2012 of operating without a valid driver's license in the 80th District Court for Clare County, State of Michigan. Is that correct?
Yes, sir.
And you were also previously convicted on or about November 26th of 2018 of the offense of police officer assaulting or resisting or obstructing in the 55th Circuit Court for Clare County, State of Michigan.
Yes, sir.
And were you also previously convicted on November 26, 2018 of the offense of a police officer assaulting, resisting, or obstructing in the 55th Circuit Court for State of Michigan?
Yes, sir.
Prosecutor satisfied with the factual basis?
Yes.
Mr. Rowe, you satisfied with the factual basis?
Yes, Your Honor.
Has the court complied with the court rules in this case, Ms. Ambrositis?
It has, Your Honor.
Has the court complied with the court rules, Mr. Rowe?
It has, Your Honor.
All right, now moving our attention to file number 18-6015-FH, in which you were on probation, Mr. Diedrich, for police officer assaulting, resisting, or obstructing. The second count of police officer assaulting, resisting, or obstructing, and a count of weapons, firearms, reckless use. 3-count violation was filed against you. That same 3-count violation was filed in file number 19-6190-FH, in which you were on probation for tampering with electronic monitoring device plus habitual criminal offender third.
Yes, sir.
The court will take judicial notice for count one of both files, which was that you violated state law by operating while intoxicated, in which you just pled to. And count two that said that you violated state law by driving a motor vehicle while your license was suspended or revoked. And count two in both files, in which you just pled to in both of those files. And was probation going to dismiss count 3, or do we want to take a factual basis for that?
Your Honor, we'll dismiss count 3.
All right. As far as the probation violations, Mr. Diedrich, you have one of 3 possible pleas to count 1 and 2. You may plead guilty, you may plead not guilty, or you may stand mute. Answering the count 1 in both files, how do you plead?
Guilty.
Answering the count 2 in both files, how do you?
Guilty.
Do you understand that if your pleas are accepted, you will not have a hearing of any kind and therefore give up the following rights? The right to a contested revocation hearing, the right to be represented by an attorney, the right to a court-appointed attorney if you're unable to afford one. Court has appointed Mr. Rowe to represent you in these matters. That the maximum possible sentence in file number 18-6015-FH is 2 years in prison. Maximum possible sentence in file number 19-6190-FH is 4 years in prison. Minimum is discretionary with the court. That you give up the right to appear at a hearing, present evidence, cross-examine witnesses. That you give up the right to have the prosecution or probation office establish a violation by a preponderance of evidence. You give up the right to remain silent and not have your silence used against you during the hearing. And you give up the right to testify at the hearing if you wish to do so and have your testimony considered in the same manner as any other witness's testimony. You understand these rights?
Yes, sir.
You understand by pleading guilty, you give up each and every one of those rights.
Yes, sir.
And has anyone promised you anything beyond what was stated in the plea agreement earlier to induce you to plead guilty?
No, sir.
Has anyone promised you that if you pled guilty, this court be lenient upon you in any way?
No, sir.
Has anyone threatened you or your family in order to induce you to plead guilty?
No, sir.
Is it your own personal choice to plead guilty?
Yes, sir.
And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, sir.
All right, and as the court said before, as pleas in the previous case support a factual basis for counts 1 and 2 in this. So we have a factual basis. Mr. Rowe, has the court complied with the court rules?
It has, Your Honor.
Court is satisfied the plea is understandably, voluntarily, and knowingly made. Pleas are accepted in order to upon the records of this court. Sentencing will be set for August 9th at 10:20 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is canceled. Cases are adjourned to the date time set for sentencing. Anything further from anybody?
No, thank you, Your Honor.
No, Your Honor.
You're all set for today, Mr. Diedrich.
Thank you.
They're all done with these, right? We can get Corey and Lane.
Find the case of the people of the state of Michigan versus William Henry Clark. Counsel identify for the record, please.
Your Honor, Austin, I'm sorry. Go ahead.
Go ahead.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Clark.
Sean resides appearing on behalf of people.
All right. And Mr. Clark is not in the courtroom. It doesn't be appearing by Zoom. Do you know where he is, Mr. Rowe?
No, I don't, Your Honor. And notice has been sent out to him about this hearing. In fact, I talked with him, I believe it was yesterday about this hearing. And if I can take a look at my notes here. Your Honor, and I've tried to, my secretary has tried to call him, his last known number, could not reach him there. So I don't know where he's at. Could I ask if the court would page him?
We'll have somebody check the district court and see if he went down there.
There's nobody down.
Nobody down there? All right. District court's closed, so nobody's there.
Okay.
So the court's gonna do, since he's failed to appear, is cancel and forfeit his bond, issue a bench warrant for his arrest. Bond in the amount of $25,000 cash surety. Find the case of the people versus DeZera, Arlena Sweet.
The prosecuting attorney Alicia Schwartz appearing on behalf of the people.
And Michael Hyde appearing on behalf of Desiree Sweet.
This is set as a final pretrial. Is DeZera Arlena Sweet available?
She is appearing by Zoom, Your Honor.
All right. You are Desiree Sweet?
Yes, sir.
All right. Court has another pretrial summary in the court file. Was there a new one issued in this matter?
Your Honor, I did forward to the court and to Mr. Hyde a pretrial summary. It contains the same offer as the last time we were in court, and one was prepared.
Your Honor, we had a motion in this case requesting for discovery material, which Your Honor granted, and told the prosecuting attorney's office to forward those materials to us. We've not received anything from the prosecutor's office in response to that order. We also are in a small tussle with Mid-Michigan Health in Clare regarding some medical records that we've also requested from them. So our discovery is not complete in this case, Your Honor.
All right.
Your Honor, in response to that, Prosecutor Ambrositis provided the report regarding the last CSC on April 29th, 2021. And I'm not sure, we did not receive any confirmation back that that wasn't received.
Well, you wouldn't have received a confirmation back that I didn't receive it if I didn't know it was coming. And the only thing I've received is a criminal sexual conduct complaint that the sheriff, the Clare County Sheriff issued, I believe. Well, this is, here, Your Honor. The date of the occurrence was 10/27/2020. The date it was reported was 2/18/2021, although my client had her blood draws done that very same day and was taken by the county sheriff's office and hospital that day. But the claim was reported on 2/18/21, and the date that this particular report was printed was 4/27/21. But I didn't get it sent to me until quite a bit after that. It was sometime in May when I received it.
So you do have the report.
I have the police report. I do have the police report, but that is not
what I said.
Yeah, that's not the same as the lab draws and the other evidence that we've requested.
We do not, as previously indicated to you, we do not have the access to your client's medical records. And I would note, Your Honor, I've had absolutely no contact with Mr. Hyde throughout this case other than one phone call that we had very early on prior to the preliminary examination. If there are issues, I certainly am available to discuss them. So if there is issues that he believes that needs discussing, I'm here. But prior to the preliminary examination is the last time I've spoken with Mr. Hyde.
Well, I've had conversations with Ms. Ambrositis since then because you were not available whenever I would call the office. Your Honor, we still need a little bit of time to complete our issues with the hospital in terms of them divulging the information for Ms. Sweet. Since she was transported there by the sheriff, they're claiming that this is evidence in a criminal case and they are resistant to giving it up. But I think we've resolved that issue finally, and hopefully within the next week or so, we should be receiving the materials we've requested from the hospital.
All right, and do you think that the Sheriff's Department has any other information that has not been forwarded, or, you know, I would suggest that you actually come, make an appointment and meet with the prosecutor and discuss stuff. If at that time you think there's something, a phone call can be made to the Sheriff's Department to see what records they do have left, if they have any. And you can get that kind of discovery done. It might be easier if you do that.
I will do that, Your Honor. I will communicate with Ms. Schwartz and make those appointments.
All right. What I'm gonna do is set this for a status conference about 45 days out, and then we'll set a trial date for about 90 days out. All right, because I don't see a trial date being in here.
Your Honor, it's set for a trial at the end of July. I believe it's set for July 29th. This is the final pretrial prior to that.
Oh, we do have a trial date, but I don't see a notice in here, but you think it's July 29th?
I have a copy of the court docket, July 29th, 9 a.m. Desiree Suite.
All right, well, I'm gonna just adjourn that because, you know, if Mr. Hyde's lucky, he'll have his information from the hospital in a week's time, but we don't know that. So I'm just gonna adjourn that. I'll set a status conference then for 30 days out and a trial for 60 days out.
Okay,
All
thank
right?
you.
Thank you, Judge.
Okay. All right.
All right.
You're all set.
Thank you, Judge.
Ms. Sweet, you're all sign off.
Thank you.
We have Mr. Lane.
I'm not sure if this is him, but I'm gonna try.
Calling the case, the People versus Corey James Lane. Counsel identify for the record, please.
Well, on behalf of the people.
Your Honor, Austin R. Rowe, attorney on behalf of Mr. Lane.
You are Corey James Lane?
Yes, sir.
This was scheduled as a final pre-trial. We do have a trial date set for July 22nd. What was the last offer in this case, Mr. Webb?
Judge, just to give you a little history, I don't know if you recall, but we reached an agreement I think in June of last year, to 12 months. And then at the time of sentencing, you said you wouldn't go on with that. We'll give him 14 months. Mr. Rowe and I have been emailing back and forth the last couple of days. And we would ask if the court would consider the same plea offers before. And if he's been in jail for 12 months or so at this point, if that would be an acceptable sentence. It may be up to 13 months by the time he would be sentenced. Is that correct, Mr. Rowe?
Yes, by our calculations, Mr. Lane was arrested, he says, I think around June 23rd, but he was arraigned on June 30th. So he's 1 day short of being 12 months in jail now. If he was to offer or accept a plea to maybe a 12-month sentence, it would still be 13 months by the time pre-sentencing report was prepared, Your Honor. So for those reasons, we're asking that the court would reconsider and agree to a 12-month cap.
Well, why don't we just do it this way, a cap at time served? And we're setting if he pleads today, I have to set the sentencing date out about 6 weeks because that's what they need to do a pre-sentence report right now. Department of Corrections is down some people and they're taking a little longer than a month to do a report.
And Your Honor, why he's asking for a 12-month cap is, I understand what you're saying. He's also he was allegedly on parole at the time that he was on parole at the time this alleged offense occurred, Your Honor. So there's the issues of where the jail credit goes. So he really doesn't want to have to go to prison on this offense, quite frankly, Your Honor.
All right. So Ms. Medley, any information on that? I mean, that's up to the parole board once he pleads and gets sentenced.
That's correct, Your Honor. That would be left up to the parole board. However, being on parole, Mr. Lane would not receive credit for the time that he has been sitting.
And Your Honor, it's just Mr. Lane's desire to finish off what he owes in this case in a county jail versus doing it in a prison, Your Honor.
All right, so if he's on parole and the court agrees to a 12-month cap, he's gonna do another year in the county jail, is that it?
That's my understanding.
All right, and you're agreeable with that, Mr. Lane?
Well, I was speaking with my attorney yesterday over Zoom, and like he said that you guys might be willing to put me on probation on this offense and let me take care of my parole violations on this case, which might send me back to prison. And so I was talking to him, well, you know, because I was already here, gonna be going on 13 months. And the judge, you offered 14 months on the charge. And I was wondering, you know, if I could be put on probation and maybe suspend the year, because I've already been here, you know, 13 months, and let me move forward and take care of this parole violation, which I might get more time out of on that, and then just, you know, move forward that way. That's what we were talking about. But yes, if you're willing to do that, I would be willing to plead guilty and take care of it and deal with my parole violations.
What I think I'll do is, we did have previously an old pre-sentence report prepared.
Yes.
The court will want to read that again before it makes a decision in this matter. And you're going to be available tomorrow sometime, Mr. Rowe?
I believe so. I'd have to check my schedule for tomorrow, Your Honor. I might be available Thursday morning if you want to do that.
We're already going to be here Thursday morning. So what I'll do is I'll look at the pre-sentence report, talk to the probation department, and then we can set this for 9:15 on Thursday morning.
I appreciate it, Your Honor.
All right.
I promise, I understand that we're not taking care of this yet, but if you're willing to do what I asked, and you know what, I mean, we've had a history, and I'm getting too old for this. I'm done. So if you agree to that issue that I spoke on, then you won't see my face in your court no more.
All right.
Thank you.
There's a jury trial date in July.
So we'll take care of it Thursday, I think.
I'm sorry?
We'll probably take care of this Thursday. The trial date's still on.
Okay.
All right.
Thank you.
Thank you, Your Honor.
Well said, Mr. Lane.
Thank you, Your Honor.
Your Honor, may I let the court know that Mr. Clark, whose case was called a few minutes ago, he just contacted my office. I think he's going to be trying to call the court pretty soon.
All right. Well, recall it when he phones in or his video's in.
Thank you, Your Honor.
Calling the case of Pig versus Jonathan Charles Davis. Counsel identify for the record, please.
Michelle Redice, appearing on behalf of people.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Davis.
Mr. Davis hasn't shown up in the courtroom. He's not zoomed in at this point, but it is just 10:30. Apparently, though, we've issued a bench warrant back in June $25,000 cash. So have you had any contacts since June?
No, I haven't, Your Honor. I sent a letter out to him on June 16th, his last known address, telling him about the bench warrant and to have him contact me, and I don't believe he's contacted me.
All right, we're gonna cancel the trial date set for July 22nd on this until Mr. Davis shows up. So we're all set with Mr. Davis. I believe that takes care of all your cases for this morning, Mr. Rowe?
Yes, Your Honor, unless Mr. Clark has tried to phone in, Your Honor.
Oh, yeah, so we'll stick around until we get Mr. Clark in.
Okay, thank you, Your Honor.
All right. Okay, Clerk's gonna take a short recess.
All right.
Thanks.
All rise. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. On the case of Ida Grove versus George Grove, counsel identify for the record, please.
Please, the court's come. Morning, Honor. John Wilson, on behalf of Mr. George Grove, the defendant in this matter. He is appearing, I am in the courtroom, he is appearing via Zoom. Your Honor, this is the time and date that's been set for a settlement conference as well as a motion hearing in this matter. Mr. Moore and I have done really good work with our clients this morning, and I believe we've come to a full resolution. I'd be glad to place that on the record and then allow Mr. Moore to do the proofs for his client, if that's what the court would like. Objection.
All right, go ahead.
Your Honor, it's my understanding that Ms. Grove is going to receive the marital home located at 4975 Clarabella Road, Clare, Michigan, 48617 in full. Mr. Grove will file it or sign a quitclaim deed giving that home to her accordingly. Ms. Grove is going to pay to Mr. Grove a $24,000 payment within 12 months of the entry of the judgment of divorce. And if not paid, the house is to be put on the market and sold, and he is to be paid this $24,000 from the proceeds of that sale. He is also to receive, Mr. Grove is also to receive, there's two checks, one in the amount of $5,600 from stimulus. Mr. Grove is going to be receiving that one. There's another check, Your Honor, of $2,400 from another stimulus. Ms. Grove is going to cooperate with Mr. Grove to have a new check issued in the amount of $1,800. And Mr. Grove is going to receive that in full as well. Ms. Grove is going to cooperate in clearing the title to a certain town and country vehicle that Mr. Grove has in his possession. It's all paid for. She just has to go to the bank and make sure the title is cleared with the bank. Each of them are to be responsible to give each other any keys that they may have for, I believe Mr. Grove may have some keys to the town and country that Ms. Grove has, and some garage keys and lawnmower keys. Any keys to any vehicles that either of them have or the house in any way are going to be exchanged between the parties. There's a PPO that was issued in this matter dated 5/12/2020. That PPO is going to be dissolved, as now that this matter is concluded, there should be no reason at all that either of these parties should be in contact with each other. Finally, I'm going to be preparing the judgment of divorce and the personal protective order dissolution and present those obviously to Mr. Moore first, but then make sure that they're filed with this court. Other than that, sorry, Judge, other than that, each of them is going to keep whatever they have as far as accounts or bank accounts, vehicles, personal property. So, sorry.
You are Ida Grove?
Yeah.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may stay at the table and you can question her there.
Thank you.
Please state your name for the record. When you filed the complaint for divorce in this matter, had you been a resident of the state of Michigan for at least 180 days before the date of the filing?
Yes.
And had you been a resident of Clare County for at least 10 days before the date of the filing?
Yes.
You and George Grove were married, correct?
Yes.
By someone duly authorized to solemnize marriages?
Yes.
Do you recall signing a complaint for divorce?
Yes.
When you signed the complaint, were all the statements true?
Yes.
Are they still true today?
Yes.
In the complaint, you stated there had been a breakdown of the marriage relationship so that the objects of matrimony were destroyed, and there remained no reasonable likelihood the marriage could be preserved. Was that true when you signed the complaint?
Yes.
Is that true today?
Yes.
You had no children born of this marriage?
Correct.
And you've heard the settlement agreement as placed on the record by Mr. Wilson. Is that your understanding about the settlement of property issues?
I do have one question.
What is your question?
that I was not aware of.
Just a moment, Your Honor. If I could.
All right.
Cooperate. I won't pay any more. Bless you. Thank you, Your Honor. Ms. Grove, the question you had was specifically about the distribution of the stimulus monies. Is that correct? And you understand what Mr. Wilson was intending, and that you will cooperate with,
Yes.
with that call. You had asked me to file a motion to enforce the settlement agreement that was entered into. You have no objection to that motion being withdrawn without any adjudication, correct? There'll be no decision about that. You have no objection to the person's protection order being dissolved, correct? But it's your understanding that Mr. Grove is to have no further contact with you or to do anything that he was restrained from doing by that order, correct?
Yes.
You're not requesting spousal support at this time, correct?
Correct.
And it's your understanding Mr. Grove is not asking for spousal support either, is that correct?
Correct.
Do you understand that by not requesting spousal support now, neither of you may later return to this court and request spousal support, is that right?
Yes.
Are you asking for your name to be changed?
Yes.
And what name would you prefer?
Yoder.
Yoder, Y-O-D-E-R?
Yes.
You are not now pregnant, correct?
No.
Do you believe there's any chance of reconciliation?
No.
You understand that if we'd gone to trial, you could have done better, you could have done worse than the settlement agreement that you placed on the record, is that correct?
Yes.
It is your desire to take the agreement and not run the risk or reward, perhaps, of going to trial, is that correct?
Yes.
Have you been satisfied with the services of your attorney in this case?
Yes.
Are you asking the court to divorce you from George Grove?
Yes.
Evan Furley.
Any questions, Mr. Wilson, of this witness?
None, thank you, Your Honor.
My only question, two questions. One is, each party being awarded their own pension rights?
Yes, sir.
Okay. And the name of Yoder, you're not doing that for any fraudulent purposes, is that correct?
Correct.
All right. All right. Mr. Wilson, you inquire of Mr. George Grove?
Thank you, Your Honor. Do you want him under oath or?
Yes. Mr. Grove, would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can put your hand down, Mr. Grove. Mr. Grove, have you been able to hear everything that we've talked about today on this Zoom call?
Yes.
You heard everything that I placed on the record relative to the agreement?
Yes.
Are you in agreement with that?
Yes.
You understand that you are not asking for spousal support today, and because of that, you cannot, it will be forever barred. You cannot come back at a later time and ask for spousal support. You understand that?
Yes.
You also understand that we did have a trial date set eventually in this matter. We would have, and you could have done much better on this case, much worse on this case, or come out just about the same in this. Do you understand that?
Yes.
Given that, are you asking this court to enter a judgment of divorce in accordance with the agreement that we put on the record?
Yes.
You also understand that there's going to be, the PPO is going to be dissolved, and you understand that while there won't be a PPO in place, there will be no reason for you to contact Ms. Grove. You understand that?
Yes.
Thank you.
Any questions of this witness, Mr. Moore? From the proofs that have been presented, it appears there has been a breakdown of the marriage relationship. To the extent that the objects of matrimony have been destroyed, there remains no reasonable likelihood the marriage can be preserved. The divorce shall be granted. Plaintiff's name of Yoder will be restored. The settlement as put on the record will be ratified by the court. The court will sign the judgment upon presentation with the inclusion of all statutory terms. Anything further?
Thank you, Judge.
Thank you. Court would appreciate it if the judgment was submitted to the court within about 30 days.
Thank you. It will be before that.
All right.
Mr. Grove, you're all set. You may hang up.
All right. Thank you.
Would the person with the phone number ending in 466 identify for the court?
Hello?
Hello, can you identify for the court, please?
William Enric Clark.
Thank you, Mr. Clark.
That's probably Mr. Eckert. Skip that.
That's a prosecutor too.
Mr. Glad? Is Mr. Clark not yours?
I got no salt and battery test.
Do you need me to call on that? You don't have to. Yeah.
No.
Okay.
Mr. Rose.
Prosecutor in just a second.
Hi, Stacy. This is Christina. Can you have Michelle log on for William Clark? Thanks.
Recalling the case of the People versus William Enric Clark, counsel identified for the record.
John Resides, Miranda People.
Your Honor, Austin R. Rowe appearing for Mr. Clark.
You are William Enric Clark?
Yes, sir.
Mr. Clark, I'm gonna warn you, you appeared late again today, or today you did, and court only waits about 15 minutes. Court had already canceled and revoked your bond and issued a bench warrant for you. But you're lucky that we're going to rehear your case and not enforce that. So we'll reinstate your bond, but this happens again, the court won't. And you'll just be thrown in jail because that's considered a failure to appear. You understand that, Mr. Clark?
Yes, Your Honor, I do.
All right, so in the future, if you get a notice to appear at 9:45, you should probably be appearing about 10 minutes early, just to make sure you're there on time. All right. This is sort of a final pre-trial. We've got a trial date scheduled for Thursday, January 29th. Any movement in this case from either side?
Your Honor, if it would please the court, can the prosecutor and I speak for a few minutes in a breakout room?
Sure, we can do that.
Thank you.
All right.
You should both get the opportunity to move now.
We have Mr. Ackerman on there.
He was supposed to be here, Your Honor, but I got a text from him last night saying he had a bit of meeting.
All right. Take a short recess then.
All right.
All rise. 55th Circuit Court's now in session. The Honorable Roy G. Meek presiding.
May be seated. Calling the case of People versus William Enric Clark.
Michelle besides me, we have people.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Clark.
So you've had some discussions with the prosecutor. Anything been resolved?
Your Honor, there have been discussions. Appears that there is no resolution. Furthermore, there appears to be a breakdown in the attorney-client relationship, especially towards the area of communication. I'm requesting the court to allow me to withdraw from this case and to appoint a new court-appointed attorney to Mr. Clark. In fact, I think I'm in both of his cases. I don't know if both of these are before the court today, but.
Oh, there's a second case too?
I believe what's before the court today is the 20-943 SM. He also has one in District Court of 2773 SM. I believe I was appointed to that one also.
Today is the 20-773-SM. That's the case I have.
All right.
If there's another case, I didn't get assigned to it.
Okay,
Mr.
thank you.
Judge Farrell did not have a conflict on the 20-0943 SM, so that is still in front of Judge Farrell. If that helps clear it up.
All right. So you're still asking to withdraw, Mr. Rowe?
Yes, Your Honor.
And the issue is the lack of communication with Mr. Clark?
It's a breakdown in communication, Your Honor.
All right. And is that because he hasn't given you a phone number that you can contact him with?
We're having troubles discussing the case with each other, Your Honor.
All right. Mr. Clark,
Yes, Your Honor.
What's your position on this?
My position is if Mr. Rowe wants to recuse himself from, hold on, sweetie. I'm sorry, I was talking to my daughter. If he wants to recuse himself, then go ahead. I have no problem with that. And there's not a lack of communication, you know what I'm saying, Your Honor. There's a lack of understanding.
Okay. And is the lack of understanding as to how you want this case to be resolved?
I guess on all fronts. basically, I was defending myself in this case, and they appointed Mr. Rowe to assist me. So some of the legal arguments, I guess Mr. Rowe's not really he's not trying to hear what I'm trying to talk about. He's trying to hurry up and just close this case. I was going to say something about his efforts regarding my case also on the second one, which is due July 15th. We haven't even discussed anything about that. We start trial to July 15th. This case is like 8 months old. He doesn't even return my phone call. So I think it is best for Mr. Rowe to go ahead and for me to seek different counsel.
Well, I'll go ahead and allow you to withdraw in this case, Mr. Rowe, and we'll appoint a new attorney. But that's going to make an adjournment probably of the July 29th trial date for this case. Do you have any objection to that, Ms. Andrus?
Are you talking to me, Your Honor?
No, I asked Ms. Andrusitis if she has any objection to that.
Okay, I'm sorry. It's hard to hear in this thing.
Your Honor, I have no objection to the jury trial that's scheduled on July 29th being adjourned.
All right. Since this is a misdemeanor, I think we'll appoint the next attorney on the list to represent you, Mr. Clark. Mr. Clark, what's your address? Mr. Clark?
Yes, Your Honor.
What is your address?
4604 North Mission Road, Rosebush, Michigan.
All right. And what is your phone number?
989-817-2466.
All right. So we'll give that information to the attorney that gets appointed to represent you on this case. We're going to adjourn this trial out another 60 days, so it'll be adjourned to September. 90 days should be sufficient for the next attorney to get ready for a trial on this case. So you'll be contacted by a different attorney. I don't know who the next person on the list is for that.
I'm taking over his cases or something.
Oh, are you?
Something's up.
Okay.
I wouldn't.
We'll appoint you Mr. Moore, who's in the courtroom, so he'll be in contact with you. And Mr. Moore, and give him all your materials, Mr. Rowe. All right?
All right.
And Mr. Rowe, if you're appointed to the other case and you need to get off that one, you better do a motion in front of Judge Farrell for that.
All right, Your Honor.
All right, you're all set for today, Mr. Clark.
Okay, thank you very much, Your Honor. Appreciate your time.
All right.
So I can just hang up now?
Yes, you can. Yeah.
Okay, thank you. Thank you. Bye.
Let's go.
No, Mr. Ackerman?
Not that I'm aware of here.
Calling the cases versus Kyle Thomas Ackerman. Counsel, identify for the record, please.
Morning, Your Honor. Mark Webb on behalf of the people.
Please, the court, Scott Moore from defense. I did receive a communication from my client yesterday. At 5:17 p.m. Yesterday evening, I received a text message from my client that states as follows: "Hey, it's Kyle Ackerman. I'm really sick. Just got to hospital. Had a temp of 102. I was having a hard time breathing. I responded at 5:36. I'll tell the judge, but I'm not sure what he'll do. If you're admitted to the hospital, have them send confirmation to my fax number or my email, and I provided both. As far as I know, we've received no communication from the hospital or any further communication from Mr. Ackerman. I do know that today was the final pretrial conference. Mr. Webb and I, based on the last pretrial conference summary, had indicated that we would be discussing some relief on the sentencing guidelines. We've made some progress on that today. I'm reluctant to ask the court for another settlement conference, but at this point, I have no further explanation for my client's failure to attend.
Any comments, Mr. Webb?
No, Your Honor, I'll leave it to your discussion.
No, that was easy.
As far as the, Mr. Moore's accurate that we're still discussing a resolution. I think we can come to that after the trial.
And in that connection, Your Honor, and I don't mean to gild the lily, but Agent Medley very helpfully pointed out some issues that came from the last pre-sentence investigation report that would have a bearing on the scoring here, so they're somewhat uncertain. We're continuing our investigation.
Why don't we put this on the docket for another status conference on July 12th at 8:45?
Yes, sir.
And the trial date is scheduled as the 21st.
21st, Your Honor, yes.
Yeah.
I'm sorry, Your Honor, what was the first date for the status?
12th, July 12th. It's a motion day. It's my first motion day in July. At 8:45.
Yes, Your Honor.
Okay. Make sure he's present.
I'll do all that I can, Your Honor, I assure you.
I know you have limited control over that.
And jury trial is
Still on.
Thank you, Your Honor.
All right. We have Mr. Knapp.
Yes, sir.
All right. Calling the case, People versus Bryant, Allen, Knapp. Counsel identify for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Karen Tomczyk, I'm here with Mr. Knapp.
And you are Bryant Allen Knapp?
Yes, sir.
And my understanding is there a plea agreement in this matter?
Yes, Your Honor.
Yes, Your Honor, that.
Mr. Knapp, how old are you?
33, sir.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And Ms. Tomczyk, he's going to be pleading to count 1 plus a tab third, is that correct?
Yes, Your Honor.
All right. And amended information has been filed, and Ms. Tomczyk, you've gone over that amended information with Mr. Knapp?
Yes, Your Honor.
And is he waiving reading of the information for today's purpose?
Yes, Your Honor.
And is previously waived preliminary examination, is that correct?
That is correct, Your Honor.
All right. Mr. Knapp, you're being charged with count 1, controlled substance possession of methamphetamine. That's a felony. It carries a maximum penalty of 10 years in prison and or a $15,000 fine. Unless sentenced to more than 1 year in prison, the court shall impose license sanctions. You're also being charged as habitual offender third offense, which means the maximum penalty can be twice that. So the maximum penalty for the controlled substance possession of methamphetamine is actually 20 years in prison. The minimum is discretionary for the court. You understand the charges and the possible penalties?
Yes, sir.
There's one of 3 possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of three possible pleas you may make?
Yes, sir.
Answering to count one, controlled substance possession of methamphetamine, how do you plead?
Guilty.
Answering to habitual offender third offense notice, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be.
Yes, sir.
Court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and having your testimony considered in the same manner as any other person's testimony. You understand these rights?
Yes, sir.
You understand by pleading guilty, you give up each and every one of those rights.
Yes, sir.
Mr. Webb, what is the plea agreement?
Judge, in exchange for the defendant's plea of guilty to count one possession of methamphetamine as a habitual third offender, I'll dismiss count two as a habitual fourth offender at sentencing. There's a Briggs Killebrew agreement to a cap of 9 months in the Clark County Jail, and if there's any restitution, that'll be determined.
Ms. Tomczyk, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Knapp, did you hear it was put on the record as the plea agreement?
Yes, sir.
Did you understand it?
Yes, sir.
And are you in agreement with it?
Yes, sir.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No, sir.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, sir.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, sir.
Is it your own personal choice to plead guilty?
Yes, sir.
And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, sir.
Drawing your attention to on or about February 3rd of 2021, were you in Garfield Township, Clare County, Michigan?
Yes, sir.
And did you have in your possession some methamphetamine?
Yes, sir.
And you knew it was methamphetamine?
Yes.
Did you have any kind of license or prescription to have that in your possession?
No.
And is it true you were previously convicted on or about October 24th of 2019 of weapons miscellaneous violation in the 49th Circuit Court for Osceola County, state of Michigan?
Yes, sir.
And we also convicted on or about March 9th of 2018 of offensive weapons miscellaneous violation and our police officer fleeing in the third degree in the 49th Circuit Court for Osceola County, state of Michigan.
Yes, sir.
Prosecutor satisfied with the factual basis?
Yes, Your Honor.
Satisfied with the factual basis, Ms. Tomczyk?
Yes, Your Honor.
Has court complied with the court rules, Mr. Webb?
Yeah, Your Honor.
Has court complied with the court rules, Ms. Tomczyk?
It has, Your Honor.
Court has not agreed upon the possible plea or the possible sentence with either the prosecutor, the defendant, or anyone acting in the interest of either. Court is convinced the plea is accurate, has been freely, voluntarily, understandably, and knowingly made. Plea is accepted. Pleas are accepted in order to enter upon the records of this court. Sentencing will be set for August 9th at 10 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Case adjourned to the date time set for sentencing. Ms. Medley, any questions or information for Mr. Knapp?
Yes, Mr. Knapp, what is your telephone number?
I have a message number. It is 231-349-7569. I also have an alternate. I also have an alternate number if you'd like that one too.
Yes, please.
231-414-1833.
And what is your current address?
9958 Birch Drive, Lake Michigan.
All right. So we will be sending out a packet of your PSI materials. There will be an agent listed on the front cover of that with a telephone number. You're to complete that packet as soon as you receive it and then contact that agent. Okay, and they'll set up an interview time with you.
Yes, ma'am.
All right, thank you very much.
Court is in recess.
All right.
Mr. Knapp, you can hang up now.
Okay, thank you.
Whenever you're ready. Hey Peggy,
Yes, ma'am?
I see that you can't see Judge Evans. He's showing up under the, I'm assuming that blank screen under Judge Mink. Is that correct?
He should be. It says Gladwin 55th Circuit. It's your court. He should be showing up.
Because I can't see.
I can see the bench.
Oh, you can?
Yeah.
But that's Clare County's bench.
No.
Only when we're talking.
No, I can see Gladwin's bench as well.
Okay, perfect. Because I'm not seeing it on our Polycom screen. That's
Gotcha.
why I'm
She looks like
asking.
a jury box at Gladwin.
Judge, whenever you're ready. Yep.
All rise. 55th Circuit Court's now in session. The Honorable Thomas R. Evans presiding.
Good afternoon. You may be seated. Calling the case of People versus Lauren Dean Robinson, file 20-6309-FH. Would counsel identify for the record, please?
Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Please, the court, Scott Moore for the defense.
And sir, would you please raise your right hand to be sworn, Mr. Robinson?
Do you only swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Could you tell us your name?
Lauren Dean Robinson.
Thank you, sir. You may be seated if you'd like. What brings us into court today is that final pretrial conference had been scheduled in this case back, I believe, on June 15 of 2021. And then a jury trial originally was scheduled for July 7 of 2021. on June 21, 2021, a hearing was scheduled, and at that time, the defendant allegedly failed to appear, at which point in time the court revoked his bond and forfeited the bond and issued a bench warrant for his arrest. Bond on the bench warrant was set in the amount of $4,000, cash only, to be posted only in the defendant's own name. Thereafter, recently, the defendant was taken into custody and is being arraigned here today on the bench warrant for the criminal contempt of court for allegedly failing to appear here in court as previously ordered back on June 21 of 2021. Mr. Moore, how does your client want to proceed today?
Your Honor, it's my client's desire to show cause why he should not be held in contempt.
All right, well, we'll schedule the matter for a show cause hearing then. And we'll schedule that matter for, this matter for a status conference then at 9 a.m. on Tuesday, July 6th of 2021. And is there anything else you wanted to address today, Mr. Moore?
Mr. Robinson asked me to address bond, Your Honor.
Wait a minute.
Yes, sir?
I did not receive any of this paperwork until yesterday.
Okay, and when you received that paperwork yesterday, did you rush down to the?
I literally took my parents' garbage out and the cops pulled up.
You are sort of spluttering, so it's hard for me to understand exactly what you're saying. So
I literally took my parents' garbage out, and as soon as I took my parents' garbage, the cops pulled up and arrested me. I just opened the paperwork.
All right, so your assertion seems to be, gee, I didn't know anything about this, but I did not voluntarily turn myself in.
I didn't have a chance to.
Because you did not have a chance to, and so therefore you feel as if, gee, I think I might be innocent of the criminal contempt of court. Correct?
Correct. You know,
very well. Then we can address those matters at 9 a.m. on Tuesday, July 6th. With regard to the bond currently is set in the amount of $4,000, cash only, to be posted only in the defendant's own name. And you have asked to be permitted to address the issue of bond.
Yes, because my mother is on hospice.
Just a moment, sir. I was not addressing you at that time. I was addressing your lawyer, Mr. Moore. Bond is set in the amount of $4,000, cash only, to be posted only in the defendant's own name. What is it you want to do regarding bond, Mr. Moore?
Thank you, Your Honor. Before I address that issue, I just want the record to be clear here. When I indicated to the court that my client wished to show cause for why he should not be held in contempt, it was firmly within the court's discretion to entertain that argument and allocution now or to schedule it for a later date. It was my direction to go forward today. The court scheduled this for hearing. Objecting to that, I simply want the record to reflect and for my client to understand that all I can do is ask for hearing from the court and within the court's discretion when the matter shall be heard. Thank you. With regard to the bond, I will state as a factual matter, we received the notice to appear for the show cause hearing scheduled for June 21st on or about June 17th. My office, under my direction, caused a letter to be sent to Mr. Robinson's last known address on Bungo Trail on June 18th. I want the court to at least consider that there was very little time between when we posted the letter and the date of the hearing. And in that connection only, Your Honor, I am asking the court to consider lowering the cash bond to an amount of approximately $500 to $700, which should assure my client's return appearance at the next hearing. Thank you, Your Honor.
All right, thank you, sir. I understand that when notice is sent by the court on June 17th regarding a hearing scheduled for June 21st, that is relatively short notice. However, based on what you have indicated today, as an officer of the court, your office at least received the communique from the court the following day on June 18, and your office promptly sent out notice that same day to your client. If your client were taking the position, gee, I didn't show up on June 21, but then I received the letter on June 22nd, for example, that would be one thing. However, we are now here on June 29th, and apparently in the interim between your office sending the letter to your client, sending it out on June 18th, now here we are 11 days later, and the defendant appears to say, to be taking the position, gee, lo and behold, I had no idea, you know, darn the United States mail or the United States postal system. I had no idea that that's why I didn't show up on June 21. Now that might be a somewhat plausible scenario if he were to, if that's what he was saying. However, it does not carry a lot of weight here on June 29th. And on what day was it that the defendant was arrested? Mr. Moore, was it today or was it yesterday?
I believe it was yesterday, Your Honor. We did not receive, I'm sorry, Mr. Robinson, if I could. I did not receive notice of today's hearing until this morning at about 8:30 a.m. So presumably my client was arrested yesterday, and I think he can confirm that.
Yes, I was arrested. Yes, I was arrested on the 28th, and I received the paperwork on the 28th. I literally got home from work, opened the mail, the paperwork was in the mail. I took my parents' garbage from their house outside of the curb, and the cops pulled up and arrested me outside immediately. I had no paperwork in 5 minutes.
Thank you, sir. That was remarkably effective police work on the part, apparently, of the Clare County Sheriff Department, and I give them kudos for their fast action. Very well then, Mr. Moore, you've asked that bond be reduced down to $700. Do the people have any position in this matter, Ms. Schwartz?
Your Honor, within the discretion of the court.
Thank you, ma'am. Very well, I'll grant your request, Mr. Moore. Bond will be set in the amount of $700, cash only, to be posted only in the defendant's own name. We'll conduct a status conference at 9 a.m. on Tuesday, July 6th. Thank you for being here, Mr. Robinson. Anything further, Mr. Moore?
No, Your Honor, thank you.
Thank you, sir, and thank you, Ms. Schwartz. We'll be in recess.
All rise.
Mr. Mr. Robinson, make sure you stop by my office when you're released and leave your phone number with us, please, or call and leave a message. We're in the book.
Okay,
Thank you.
thank you.
You're all set, sir.
See you, ladies.
May be seated. On the matter of Pitt versus Vance Lee Willard. Set for a show cause today at 1 o'clock. He's failed to appear. He did make a payment. Okay. Matter of Thomas Lee Van Sickle. He makes a payment of $150. The court will forgive the remaining balance. It's $960. Matter of People versus James Arthur Montalvo. He has to pay in full by July 9th. If he fails to do so, a bench warrant can issue.
I have to log you off. You gotta do the thing. Which way?
Commissioner resides Paramount People.
Please, the court's got one.
You are Anthony James Menny?
Yes, sir, I am.
How are we proceeding today, Mr. Moore?
Thank you. We're having some discussions with the prosecuting attorney and my client. We will accept the offer on file. Oh, golly. 21-006573-FC. Mr. Manning will plead guilty to operating while intoxicated, third offense notice as an habitual offender, third. And then as regards the probation violation that I just now signed the substitution on, it's a comp check. We would be proceeding with the plea and agreement in that file as well.
Mr. Menny, how old are you?
29, sir.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Mr. Moore, you've gone over the amended complaint with your client, is that correct?
Yes, Your Honor. Waive reading of the information and waive preliminary examination.
Mr. Menny, you're being charged with operating while intoxicated, third offense notice. That is a felony. It carries a fine of $500 to $5,000, either 1 to 5 years in prison or probation with 30 days to 1 year in jail. You'll be ordered to do at least 60 days of community service. It could be up to 180 days. You could be ordered into rehabilitative programs, pay costs of prosecution, or to reimburse the government for any emergency responses, and mandatory vehicle immobilization not less than 1 year or more than 3 years. You're also being charged as habitual offender fourth, which makes the maximum penalty life in prison.
I'm sorry, Your Honor. The agreement was to a third offense.
Have third. And which means the penalty could be double that. 10 years would be the maximum penalty possible. The minimum is discretionary with the court. You understand the charges?
Yes, Your Honor, I do.
And you understand the possible penalties?
Yes, sir.
of three possible pleas you may make to this charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of three possible pleas you may make?
Yes, Your Honor.
Answering to operating while intoxicated, third offense notice, how do you plead?
Guilty.
Answering to habitual offender, third offense notice, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be.
Yes, Your Honor, I do.
Court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, sir.
You understand by pleading guilty, you give up each and every one of those rights.
Yes, sir.
Mr. Mercedes, what is the plea agreement?
Your Honor, in return for the defendant's guilty plea to operating while intoxicated third offense as a habitual third offender, the people would agree to a Briggs Killebrew cap of initial incarceration at 12 months. There is a $100 cost of law enforcement, actual cost of prosecution, restitution for the blood draw, which is $35. Pay for day credit for inpatient treatment successfully completed. And any sentence would be concurrent with any other sentences currently serving.
Mr. Moore, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Menning, did you hear it was put on the record as the plea agreement?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
And are you in agreement with it?
Yes, Your Honor.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No, sir.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, sir.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, sir.
Is it your own personal choice to plead guilty?
Yes, sir.
And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, sir.
Drawing your attention to on or about
February 11th.
February 11th, 2021. Were you driving a motor vehicle?
Yes, Your Honor.
Mystic Lake Road, Garfield Township, Clare County, Michigan.
Yes, sir.
And prior to driving that motor vehicle, had you been drinking some alcohol?
Yes, Your Honor.
Do you remember what kind of alcohol you were drinking?
Fireball whiskey.
And do you know how much you were drinking?
No, Your Honor.
Enough to make you intoxicated?
Yes, Your Honor.
We should put on the record the blood alcohol level.
I had it right here.
0.246.
We would stipulate to that 0.246.
All right. It's about 3 times what's necessary. Is it true, Mr. Minnie, that you were convicted of operating while intoxicated on or about December 17th, 2019? in the 55th Circuit Court of Clare County, Michigan.
Yes, Your Honor.
And we also convicted of operating while intoxicated on or about December 18th of 2019 from the 80th District Court for Clare County, Michigan.
Yes, Your Honor.
And we also convicted on or about June 17th of 2020 of the offense of larceny after breaking and entering.
No,
And
Your
that
Honor.
was, no, that would have been in Scotland County, state of North Carolina.
That would have been, yes, Your Honor. That was in 2009.
2009, not 2020.
Correct.
And we also convicted down there of offense of breaking and entering with intent to commit a felony in that county and state of Carolina around that same time, 2009, 2010.
Yes, Your Honor.
Your Honor, the habitual notice that I'm looking at recites offense date of honor about June 17th, 2010 in each offense. Is that correct, Mr. Benny?
That might have been, yeah, that might have been when I was sentenced. Yes, sir.
Very good. Yes, thank you.
Prosecutor, satisfied with the factual basis for those, please?
Yes.
Satisfied with the factual basis, Mr. Moore?
Yes, Your Honor.
Has court complied with the court rules, Ms. Ambrositis?
It has, Your Honor.
Has court complied with the court rules, Mr. Moore?
Yes, Your Honor.
Drawing your attention to file number 19-6216-FH, in which you're on probation for 2 counts of police officer assaulting or resisting or obstructing. Those were felonies that carried a maximum penalty of 2 years in prison. 6-count violation was filed in that matter. Which counts did you want to proceed in this case, Mr. Moore?
I would defer to Ms. Medley.
Your Honor, I believe it would be count 5 and the remaining will be dismissed.
All right. Count 5 is violation of Rule 1. One of 3 kinds of pleas you may make to this, Mr. Money. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute. You understand the one of 3 possible pleas that you may make?
Yes, Your Honor.
Count 5 is violation of Rule 1, not violate any criminal law of any unit of government. It states about February 11th of 2021, you were driving while intoxicated. How do you plead to that?
I'm guilty, Your Honor.
You understand that if your plea is accepted, you will not have a hearing of any kind and therefore give up the following rights: the right to a contested revocation hearing, the right to be represented by an attorney, the right to a court-appointed attorney if you're unable to afford one. Mr. Moore is representing you on this matter. That the maximum possible sentence could be 2 years in prison. The minimum is discretionary with the court. They give up the right to appear at a hearing, present evidence, and cross-examine witnesses. You give up the right to have the prosecution or probation office establish a violation by a preponderance. You give up the right to remain silent and not have that silence used against you during the hearing. And you give up the right to testify at the hearing if you wish to do so and have your testimony considered in the same manner as any other person's testimony. You understand these rights?
Yes, Your Honor.
You understand by pleading guilty, you give up each and every one of those rights.
Yes, sir.
Has anyone promised you anything to induce you to plead guilty in this matter?
No, sir.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, sir.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, sir.
Is it your own personal choice to plead guilty?
Yes, sir.
And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, Your Honor.
Court will take judicial notice of his plea in the other case today. There's the factual basis for the charge. You agree, Mr. Moore?
I do.
Does court comply with the court rules?
Yes, Your Honor.
or it is not agreed upon the possible plea or the possible sentence. In either case, with the defendant or the prosecutor or anybody acting in the interest of either, court is convinced the pleas are accurate, have been freely, voluntarily, understandably, and knowingly made. Pleas are accepted, ordered entered upon the records of this court. Sentencing will be set for August 9th at 8:45 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bonds are canceled. Cases are adjourned to the date time set for sentencing.
Your Honor, I don't know if the prosecutor wants to address the forfeiture action at this time. We're waiting for consent.
I do, Your Honor. We do have a stipulation in order to relinquish and transfer title. Mr. Moore gained permission to sign his client's name. We would just need you to sign and date the order, return it to us, and we'll file it with the court.
Mr. Nenny, as we discussed, you did authorize on your behalf the forfeiture action. I have discussed this with the prosecutor. If you could provide the name and telephone number of a person who would be responsible for retrieving your personal property from the vehicle before it is placed up for sale, I certainly appreciate that. Is that something you can do now, or would we have to do it later?
I can provide the name now and the phone number later, if that's helpful.
What's the name?
Jerry Schilling.
Will you be speaking with Mr. Schilling the next day or so?
Yes, Your Honor. I mean, yes, sir. Sorry. Yes, Your Honor.
Thanks for the promotion. We're not there yet, and it doesn't look likely, but thanks. No, have him call my office or my cell phone, and we'll get that information to the prosecutor. All right?
I will do that.
Thank you. I have it. Thank you.
All right. You're all set, Mr. Benny.
Thank you, Your Honor.
Are you ready to go to the next case? Do we have people in the Zoom?
I do, and I believe everyone's sort of here.
I guess that's it.
I have the case of Tammy Hamilton versus Bradley Martin, Bonnie Martin, and Bradley Martin and Bonnie Martin versus Rodney Dent and Nancy Dent, and Lawrence Hovey and Diane Hovey, and the LAFCU LLC. And you have the Hoveys as cross plaintiffs against the Dents. And then you have third-party plaintiffs against third-party defendants, Kelly Ritzel at Big Rapids Realty, Inc. Counsel identify for the record, please.
Good afternoon, Your Honor. Janie Haroff, appearing on behalf of plaintiff Tammy Hamilton.
You can take off the mask if you wish.
I promise I'm vaccinated. We went with alacrity.
Other counsel's appearance? Oh, you have to unmute.
Robert Backus on behalf of Mr. and Mrs. Dent. I'm sorry, Mr. and Mrs. Hovey.
Your Honor, can you hear me at this point?
Yes.
Sorry about that. This is Paul Blanco appearing on behalf of Jeffrey Klaus, attorney for defendants, the Martins.
Jason Sifford here on behalf of Kelly Reitzel and Big Rapids Realty. I'm a
co-counsel with Scott Kramer. I work at a firm with him.
Do I have anybody else?
Well, I don't know if Mr. Higgs was planning on appearing.
Anybody else in the room? All right. So Mr. Higgs has not appeared and doesn't appear like any of the parties have.
Miss Diane Covey is on, but she is muted.
Okay.
And no.
All right.
That's Mr. Backus's client.
Okay. All right, we're here today for plaintiff's motion for summary disposition. You may proceed.
Thank you, Your Honor. The court may remember that this is a two-pronged case. We have a boundary correction action, and an ancillary to the boundary correction action, we have a fraud case, and we asked the court to sever those, and the court did that. I am here today asking the court for summary disposition with respect to the boundary correction case. And the bottom line on that is, I briefed it, I briefed the evidentiary aspects of it. We filed verified complaints, so they stand in the place of an affidavit. We filed a certified copy of the chain of title from the Register of Deeds. And Mr. Klaus pointed out that defendant, cross-defendant, Dent's answers to interrogatories also factually support our motion. We filed this in July of 2020, and it took a fair bit of the remainder of 2020 to get all of the parties present for the litigation. And now we're halfway through 2021, and the only survey in the folder is the survey that reflects the boundary correction we're asking the court for. There has been opposition. Mr. Dent has said no, he doesn't agree to it. He was the former owner of Hobie's house, but they haven't provided any factual basis that I'm aware of for that. And in fact, in the answers to interrogatories, basically said, cited by Mr. Klaus in his brief, that the boundaries were agreed to by the parties. The certified chain of title reflects that the plat was filed in 48, which your typical plat in the Farwell area. Herschel and Velma Reese were busy in it. They sold the property. The owner built the house apparently in the 60s, as set forth in the brief, and at the point I illuminated, he's listing that address as his house. So we can take that as a general thereabouts for when the house was built. There isn't any evidence that it benefits anybody to have legal descriptions that bisect their homes. And so we're just asking the court to give us our boundary correction at this point and let us exit the litigation.
Mr. Blanco, on behalf of your parties, any comments?
Your Honor, we have no objection to the boundary correction. I did read some of the, the motions. I was given to understand there was also some issue about the status of title that that's being sought. So long as this decision doesn't reach that issue and only addresses the boundary dispute, we are in full agreement.
Are you asking only for the description at this point, or are you also asking for the deed?
Mr. Klaus and I have discussed this at least 5 times, and the land contract is really bad. There was a bunch of pals doing a land contract between themselves. And it says something to the effect that the seller is to relinquish all right, title, and interest when it's paid off. So their position is that that requires a quitclaim deed, and truthfully, while I would love a warranty deed, I probably can't make that argument in front of the court and retain the court's confidence if the court looks at the land contract.
All right. Mr. Backus, on behalf of your clients?
Thank you, Your Honor. On behalf of Mr. and Mrs. Hovey, we object to the granting of the motion for summary disposition with respect to the boundary adjustment. I don't believe that the motion's been properly supported as required by Michigan Court Rule 2.116 sub G, sub 3, which requires affidavits, admissions, and other documentary evidence in support of a motion under C10, and also requires that all of that be admissible. And in the form that we have as the attachments to the motion and the allegations set forth in the motion, I don't know that we have adequate admissible evidence to grant a motion for summary disposition. As the court is aware, quiet title actions are inherently tied up in factual allegations and claims, and they require clear and cogent proof. Obviously, conceptually, what we're looking at is removing property legally titled to Mr. and Mrs. Hovey and giving it to somebody else. I think the courts historically in Michigan have proceeded very cautiously in that regard to make sure that there's a clear record that all the elements of adverse possession, each and every one of them, are fully met. And I don't believe that we've got that record here based on the filings attached to the motion for summary disposition. So we'd ask that the court deny the motion as being improperly supported.
So are you saying that the Dunt's admissions to the interrogatory are not admissible evidence?
I don't know that they rise to the level that that adjusts boundaries. I don't know that their answers to interrogatories go to the point of saying that this is now the proper boundary and that Mrs. Hovey and Mr. Hovey lose half of their property, which also means they lose their mortgage, which also means they're in default on the terms and conditions of their note. And they've got significant problems as a result of this. They purchased this property from Mr. and Mrs. Dent almost, I would say, within months before this litigation was filed. Mr. and Mrs. Dent, based on our fraud claims, had full knowledge of this, didn't disclose it to Mr. and Mrs. Hovey, and left us in this position of having to defend this motion with no support from them. We don't have a filing on behalf of Mr. and Mrs. Dent objecting to the motion. So I just feel like there should be a more clear record of where the boundaries are supposed to be developed at trial. And in full candor, Your Honor, Mr. and Mrs. Hovey don't have a basis for factually disputing the allegations in Ms. Haroff's complaint. And I'm just trying to be as candid as I can be with the court.
On behalf of the Realty, got your name?
Oh, thank you, Your Honor. At this time, we won't take a position on the motion pending before your court.
Okay. Any rebuttal in this far off?
I think the key thing that Mr. Backus said is that Mr. and Mrs. Hovey, being the newbies in the neighborhood, are not themselves in possession of any facts to contradict what has been said. Mr. and Mrs. Dent and their counsel have half-heartedly participated in this. We get pleadings, sometimes timely, and have asserted that the boundary correction should not be granted, but they have no skin in this game in terms of whether or not the boundary bisects your house. The truth of the matter is Hobies do lose a portion of their lot, but they don't lose a portion of their lot as occupied. And the companion lawsuit to this will be the next boundary correction down the line, which is in fact the last lot before the road. So there is a limit to the number of boundary corrections the judge will have to do.
Well, the court has reviewed through the motion, the reply briefs, the exhibits in this matter. It's pretty clear to this court that the boundary line is as occupied. Whether you want to say it's through adverse possession or acquiescence, the dense interrogatory answers really show it up. And if they were to take the stand and testify to something differently, then their interrogatories would be admissible. So I think we do have some admissible evidence. I think it's pretty clear, it doesn't matter whether it's acquiescence or adverse possession, that this has been going on for over 40 years. People have been occupying their lots and houses, even though the survey lines are wrong. So court's going to grant summary disposition to the plaintiffs as to the lots as occupied. Now, there could be a little difference as to what we think the survey lines are there, but that may be scheduled for another date if you can't agree on it.
I will circulate a judgment for signature, see if there is any dissent.
Okay.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
We're in recess. All right.
Why are you taking out my phone?
I decided to come out of my.
General Roy J.B. presiding.
You may be seated. On the cases of the people versus Eric Danya Heron. Counsel identify for the record, please.
Service as appearing the people.
John Melton for the defendant.
You are Eric Danya Heron?
Yes, sir.
And how old are you?
41.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I have new pretrial summaries for file number 21-6539-FH and 21-6540-FH, and we're going to be proceeding on those cases today. Is that correct?
That's correct.
Mr. Melton, you've provided your client with copies of the informations or gone over those informations with your client. Is that correct?
Yes, Your Honor.
Is he waiving reading of the informations for today's purposes?
Yes. Yes.
And previously waived preliminary examination appears. Is that correct?
That's correct.
File number 21-6539-FH. Mr. Heron, you're being charged with count 1, tampering with electronic monitoring device. That's a felony. It carries a maximum penalty of 2 years in prison and or a $4,000 fine. You're also being charged as habitual offender third offense notice. That makes the penalty twice that amount, so the maximum penalty is 4 years in prison. The minimum is discretionary of the court. Do you understand the charge and possible penalties in that case?
Yes, sir.
File number 21-6540-FH. Being charged with count 1, police officer fleeing in the 3rd degree, a felony that carries a maximum penalty of 5 years in prison and/or $5,000 fine. The Secretary of State will suspend your driver's license, and you're also being charged with count 2, police officer assaulting, resisting, or obstructing, a felony that carries a maximum penalty of 2 years in prison and/or a $2,000 fine. Consecutive sentence may be imposed if the assault was committed in a place of confinement or arising from a violation from the same transaction. You're also being charged as habitual offender 3rd, which means count 1 has a maximum penalty of 10 years in prison, and count 2 has a maximum penalty of 4 years in prison. The minimum is still discretionary with the court. You understand those charges and the possible penalties?
Yes, sir.
There's one of 3 possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stay on mute, in which event the court will enter a plea of not guilty for you. Do you understand the one of 3 possible pleas you may make?
Yes, sir.
Answering in file number 21-6539-FH to count 1, tampering with electronic monitoring device. How do you plead?
Guilty.
Answering to the habitual offender notice and a 3rd offense notice in that. How do you plead?
Guilty.
Referring to file number 21-6540-FH to count 1, police officer fleeing in the 3rd degree. How do you plead?
Guilty.
And to count 2, police officer assaulting, resisting, or obstructing. How do you plead?
Guilty, sir.
And to the habitual offender 3rd offense notice. How do you plead?
Guilty.
Yeah.
Understand that no one may make any promises for this court as to what your sentence will be.
Yes, sir.
Court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, sir.
You understand by pleading guilty, you give up each and every one of those rights.
Yes, sir.
Mr. Ambrositis, what is the plea agreement?
Your Honor, file 21-006539FH. In return for the defendant's plea of guilty as charged, the people would agree pursuant to Briggs and Killebrew that this would be a 12-month cap on initial incarceration. The restitution would be determined to the Michigan Department of Corrections for the damaged tether. We would also agree that the sentence is to run concurrent with file 21-006540FH. We would also agree to a PR bond with a GPS tether upon entrance of a plea in this case and in the 6540FH case, with the agreement that the defendant will state on the record that he will waive extradition and he will surrender his passport to the court if he has one, and that he will pay any associated extradition fees if he does leave the jurisdiction unauthorized. The plea agreement and bond agreement on these 2 cases is separate and apart from 21-006585FH. And then in file 21-006540FH, in return for the defendant's guilty plea to counts 1 and 2 as a habitual 3rd, we would dismiss the remaining counts in that file upon sentencing him under the appropriate appeals period. And again, in that file, we would agree pursuant to Briggs and Killebrew to a cap of 12 months initial incarceration. And again, all of the other terms and conditions that I stated on the record with regard to the other case would also apply in this particular case, and I would again stress that our agreements in these two files have no bearing on file 21-6585 FH. In that case, will stand alone and continue to pen trial.
Mr. Melton, is that your full and complete understanding of the plea agreement?
It is, Judge. It is my understanding of the plea agreement. And at the appropriate time, though, I'd also like to address bond, and the 6585 case is still pending for trial. But as far as the.
We'll do that,
that is
we'll do that after we get done with this. All right.
Okay.
Mr. Herring, did you hear what was put on the record as the plea agreement?
Yes, sir.
Did you understand it?
Yes, sir.
And are you in agreement with it?
Yes, sir.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No, Your Honor.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, Your Honor.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, Your Honor.
Is it your own personal choice to plead guilty?
Yes, Your Honor.
And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No, Your Honor.
Have you understood everything that the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, Your Honor.
Drawing your attention to on or about December 9th of 2020, were you in Hayes Township, Clare County, Michigan?
Yes, sir.
And did you knowingly and without authority remove an electronic monitoring device that you were using?
Yes, Your Honor.
And you had that electronic monitoring device that was a GPS unit of some type?
Yes, Your Honor.
And you removed it from your leg?
Yes, Your Honor.
And you didn't have any authority to do that, is that correct?
No, sir.
Not correct?
No, it's correct, sir. I didn't have the authority to remove it, no.
All right. And is it true that you were previously convicted on or about January 7th of 2013 of the offense of conspiracy operating, maintaining a laboratory involving hazardous waste in the 55th Circuit Court for Clare County, state of Michigan?
Yes, Your Honor.
And were you also convicted on January 7th of 2013 of the offense of conspiracy operating, maintaining a laboratory involving hazardous waste in the 55th Circuit Court for Clare County, state of Michigan?
Yes, Your Honor.
Drawing your attention to on or about December 19th of 2020. Were you in Hatton Township, Clare County, Michigan?
Yes, Your Honor.
And were you driving a motor vehicle on that date?
Yes, Your Honor.
And were you given a visual or audible signal by hand, voice, emergency light, or siren by a police vehicle to pull over?
Yes, Your Honor.
And you knew it was a police vehicle?
Yes, Your Honor.
And you know it was a police officer driving that vehicle in the lawful performance of his duties?
Yes, Your Honor.
And did you fail to pull over for him?
Yes, Your Honor.
And you did that willfully, is that correct?
Yes, Your Honor.
And did you otherwise speed up or attempt to flee from or elude the officer?
I continued driving, yes.
All right. And that was an attempt to flee from the officer?
Yes, Your Honor.
All right. And was this done in an area, residential area, where the speed limit was less than 35 miles an hour?
It ended up into one. I drove to the police station. So, yes, I think that's, I'm not sure if that's 35.
You're not contesting that. You're not saying that's not true. Right?
You're not contesting that it was, the speed limit
No.
was 35 miles or less than some of the streets?
Correct.
Okay. And when you finally pulled over, an officer was behind you and he pulled out, and did you assault, batter, wound, resist, or obstruct, or oppose, or endanger that officer?
Yes, Your Honor.
And he was in a uniform, so you knew it was a deputy sheriff?
Yes, Your Honor.
And you knew that he was doing his job, performing his duties as a sheriff deputy?
Yes, Your Honor.
Satisfied the factual basis for both cases, the court will take judicial notice that he already agreed to the prior convictions for habitual offender.
Yes, Your Honor.
Satisfied the
satisfied.
factual basis, Mr. Melton?
I'm satisfied, Judge. Thank you.
Has court complied with the court rules, Ms. Ambrositis?
It has, Your Honor.
Has court complied with the court rules, Mr. Melton?
Yes, I'm satisfied, Judge.
Court has not agreed to possible plea or the possible sentence with either the prosecutor, defendant, or anyone acting in interest of either. The court is convinced the plea is accurate, has been freely, voluntarily, understandably, and knowingly made. Pleas are accepted in order to enter upon the records of this court.
Your Honor, we'd ask for sentencing to be set after the jury trial in the other case, which is scheduled to go in August, I believe.
Yeah, I was gonna set it for September 27th at 11:30 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Pursuant to the agreement, these two cases, the bond will be changed to a PR bond. And he would be allowed out on the PR bond as soon as a GPS tether is attached to him. So he's not going to get out on the PR bond until has a GPS tether attached.
Thank you, Your Honor. For purposes of extradition, can you have him acknowledge on record that he's waiving that extradition?
And Mr. Herron, are you agreeing to waive extradition if you, for some reason, leave the state?
Yes, Your Honor.
And you're agreeing to turn in any passport, if any, that you may have?
Yes, sir. I don't have one, but yes, sir.
Okay. Anything else regarding those two cases?
No, thank you.
Not regarding those two cases, no, Judge.
All right, find the case. File number 21-6585-FH.
Mr. Ambrositis, you have the people?
John Melton for Mr. Herron.
All right.
You're-
Go ahead.
No, we're going to continue the trial in this case, Judge. I wanted to address bond. Mr. Herron still left with a $300,000 cash surety only bond, which is not obtainable for him and his family. He certainly has a big incentive to stay in the county, Judge. As far as I know, he hasn't missed a court date. Not in these cases. I wasn't the first attorney hired, but he hasn't missed a court date. As I stated in my previous motions, Judge, his mother is very, very sick. She's getting elderly. She needs Eric to take her to the hospital and to the doctor. She agrees to kind of act as a more or less a trustee for him if they needed, kind of like they do in federal court. But I think
she will vouch for his appearance in court.
Yes.
All right.
Discuss that with her. And with all due respect, I think $300,000 cash surety in this case, I think, is, with all due respect, excessive. And I would respectfully request the court consider either a PR bond or at least a 10% bond for Mr. Herron.
All right. Ms. Ambrositis, on behalf of the people.
Thank you, Your Honor. For all previous issues that we've stated, every time the defendant has made a argument for reduction of bond, we incorporate those here and object to any reduction.
All right. Court will allow the bond to be 300,000 cash surety or 10%. So we'll make that change. Make sure that you appear in court every time you're necessary, or appear at the Department of Corrections whenever required. Ms. Medley, do you want to talk to Mr. Herron right now?
Yes, Your Honor. Mr. Herring, are you still residing at 155 West Pine Street, Harrison, Michigan?
No, ma'am.
Okay, what is a current address for you, sir?
4947 Edgewood Drive, Harrison, Michigan.
And what is a current phone number?
989-539-6306.
Okay, I will be dropping off some PSI packets for you at the jail before you're released. So I'll have them over there tomorrow morning for you, okay?
Yes,
All right. Thank you.
thank you.
If for some reason you bond out tonight, Mr. Herring, then you need to call the Department of Corrections to make arrangements to pick up those PSI interview forms.
Yes, sir.
All right?
Is that right at the courthouse?
Yes. Any specific phone number he should call to make those arrangements if he does bond out tonight?
He can call 989-598-5945.
Thank you.
You have that, Mr. Melton? You'll make sure that that occurs?
Yes, Your Honor, I have it. And I'll make sure. Thank you.
All right. Anything further from either party?
No, thank you, Your Honor.
Nothing further today, Judge. Thank you.
All right, we're in recess.
All right.